over the residential real estate listing agreement that gives me, your agent, or us, your brokerage, the exclusive right to sell/market your property. This won't be a fun video, but it will be informative. And the purpose is to give you a brief overview of this document so you can kind of know what you're signing. I definitely would encourage you to take the time to read the entire document. This is just a quick interpretation of some of the paragraphs. We won't go over every single thing, but we will touch on a lot of this. So hope you enjoy it, and I hope it's informative. Okay, so let's start with the first part of this agreement. So paragraph 1 is the parties. That's going to be yourself, should have your address on your contact information, and then the broker, so our company, and it should have all of our contact information as well. Next, you will see that the seller appoints the broker as the sole. Next, you'll see that seller appoints broker as seller's sole and exclusive real estate agent and grants the broker the exclusive right to sell the property. Next, it's going to talk about the actual property. Property is going to be the land, improvements, anything attached to the land. So this is going to be the legal description of your property. This will talk about the improvements that convey with the property. And one thing that really pops out here is anything permanently installed and built in, okay? So if you turn the house upside down, if you have to shake it for the thing to fall off, then that probably means it's a part. So be sure to take your time and read through this entire thing, because it's going to be light fixtures, chandeliers, water softeners, garage door openers, everything. So make sure you read through this so you can know exactly what all conveys with your property. And this section D is going to be the section where you can list anything that you might want to exclude. So curtain rods are a part of it. If you want to exclude those curtain rods, we're going to put them right here. All right, let's move on to the next page. This section E here, it talks about if your property is a part of any HOA, homeowners association, and so we'll check if it is or if it isn't. This is going to be the price that we agree to, and we can always change that later if we need to, but this is going to be the price that we start at. Number 4 talks about the term, when it begins and when it ends. We should have talked about that before, and so those days should sync up to the ones that we talked about. And it says, if seller enters into a written contract to sell the property before the date of this listing begins and the contract is binding on the date this listing begins, then the listing will not commence and be void. So if you sell it before the date on the listing agreement, then our listing agreement is void, okay? Compensation, so it will have the amount that we have agreed to here. Now, just a quick heads up, it will have the total amount that we agreed to. And if we agreed to give the buyer's agent that brings us a buyer a commission, that portion of the commission will also be here as well. Okay, and this just says what I have to do to earn the commission. And it is to essentially procure a ready, willing, and able buyer to buy the property at the listing price or any other acceptable price. And it says that the commission is payable once we have basically procured that buyer. And it's not payable if the property does not close as a result of we can't deliver the deed or the title policy. So if something is amiss with the ownership, then my commission is not due and we have to terminate the deal. So just keep that in mind. Read this section of what you have to do to breach this contract. So if we go under contract, you collect the earnest money and then decide, okay, I just don't want to sell my house. Well, then you will probably be in breach of this listing agreement and the sales contract. And at that time, commission is still payable. So it's something that we would need to discuss, okay? Service providers, if I have a relationship with any service providers, then that means that I'm going to need to disclose that to you, and absolutely will. Over here on section E, the protection period, and I usually put a time of about 10 days here, and this just means that anybody who came to see the house while it was listed with us, if they purchased the house within the certain amount of days that we list here, then we are still due commission. Okay, so read through that. And make sure you understand all of those things. When it comes to county, so it means all amounts of commission are payable in, we're going to do Williamson County here because that's where our home brokerage is located. And escrow authorization. So this authorizes me to instruct the title company or escrow company to close the transaction and get any property information that they need to collect. Listing services. So this says that we can market the property and MLS rules may apply. And this also says that I will or will not file it with the MLS. Most times we will do that. And then it says how many days after we file. And then on this 1B, it says how many days after our listing agreement begins will I actually file this in the MLS. So that's something that we will agree upon beforehand. All right. And it just says we're going to follow all of the MLS rules. Listing content here just means anything that we do to market the property, pictures, video, all of that is owned by the brokerage, and you are giving us permission to distribute that wherever we see fit. Number 7 is access to the property. So it just says that you're going to participate with giving us access to the property at reasonable times. Now, we're never going to try to inconvenience you, but we are asking that you make the property accessible to potential buyers, inspectors, appraisers, everybody in between. The scheduling company is here on section B. We typically use Showing Time, and that's just going to be the company that we use to facilitate showings. They're going to track the people that are showing the house and help us with the scheduling. The key box is another important thing. So it says that you either let me or you do not let us put a key box on the property. And that's something that we can definitely talk about beforehand. If there is a tenant in the property, then all the tenant's rights are in place. Typically, tenants need about 24 hours notice before they have to let someone in. Liability and indemnification, this just means, hey, if something happens in the house that we had nothing to do with, then we are not liable. Make sure you read through all of the details on that. And we're going to talk about cooperating with other brokers on section 8. So that's the portion where we said if a buyer's agent brings in a buyer, then this is where the amount of commission that is due to them is going to be laid out. So MLS participants are people that are a part of our MLS, local, a part of our board. Their percentage will be listed here. And if they are non-MLS members, then their commission is going to be listed there. The intermediary, which basically means a agent from my same brokerage has brought us a buyer, and you are either allowing us or not allowing us to both work that file. Now, there will be a clear disclosure that says agent A represents the seller, agent B represents the buyer. Never will we do dual agency where we represent both parties. It is impossible for us to have the best interest of both parties in mind when it comes to negotiation. So there will always be one agent assigned to either the buyer or the seller. This intermediary just means that we are a part of the same company. Now, our company is really, really large, so there are good odds that we may have a buyer's agent from our same company. So that's just what that intermediary status means. If you don't want to do that intermediary status, then you're able to check it here on B. And then this just kind of gives you more details about what that means. Paragraph 10, anything that you say to me that is supposed to be confidential will stay with us, all right? And broker's authority, broker will use reasonable efforts and act diligently to market the property for sale and procure a buyer, all right? So it just means we're gonna do our jobs and we're gonna do it to the best of our ability. If you want me to check on section B1 and you don't want us to display this on the internet, just let us know. Most homes sell on the internet, so you're probably gonna wanna do that. And number C, this is going to say what type of loans that we're going to be marketing for. Now, this all depends on your property. Not every property is eligible for every type of loan, but you will see the types of loans that your specific property is eligible for checked here. All right. And this says on section D that we're going to act in accordance to MLS rules as outlined in paragraph 6. And this gives us the right to do a bunch of different stuff like advertise your property, put a for sale sign in the yard, advertise during, on, or after the listing ends that the broker sold the property. So these are just all the things that we can do on your behalf. Make sure that you read through all of this because this really talks about most of our marketing efforts. And I am not authorized to execute any document in the name of or on behalf of the seller. That's what section E says right there. Okay. And on 12, these are seller representations. These are the promises that you are making to us. This is you saying that there are no liens on the property and there is nothing that you don't have an agreement with another broker or anything of that nature. So make sure that you read through this and fill in anything that applies to you, but these are all of the promises that you as the seller are making. Section 13, additional promises. Okay, so we already kind of talked about facilitating showings, marketing, and sale of the property. You won't rent it or lease it, and you can't negotiate with any prospective buyer. You're going to leave that to us. So please make sure that you read this. It also says you're going to maintain any pools or just maintaining the property. Read through this additional promises section. And limitation of liability. This also is another section that says we are not liable if anything happens on the property that we're not responsible for. If anyone gets injured or if something happens during a showing, we are not responsible. So if it is not a direct act of the broker, then we will not be held liable. So make sure that you read through all of that. If there are any special provisions that needed to be added, they will be here. And let's talk about the default part. So if the seller does not cooperate with the broker to facilitate showing, marketing, or sale of the property, or otherwise breaches the listing, then seller is in default and will be liable to broker for the amount of the broker's compensation. So if we can't work together and play nice, something happens, then we are still going to be due compensation via the commission that we spoke about earlier. This section says that we will try to mediate before we litigate. So we'll try to come to terms on things if you and the brokerage have an issue, or if you and the buyer have an issue. We'll always try to talk through it, work through it the best we can before we go to court. All right, let's talk about attorney fees. If seller or broker is prevailing party in any legal proceedings brought as a result of a dispute under the listing or any transaction related, then such party will be entitled to recover from the non-prevailing party all cost of such proceedings and reasonable attorney fees. So if we get into some sort of litigation, the loser is agreeing to pay the attorney fees of the winner. Other addenda and documents. So a couple of these may be checked, and we'll talk about each of those individual documents if you see them here. But this is just saying that, like your seller's disclosure is another thing that you'll receive, information about brokerage services, maybe the T47 affidavit with your existing survey. These are the most common documents you'll see. All right. So, and this just says that agreement of parties, that we're agreeing to a binding contract. And this is going to be governed under Texas law. Additional notices, please review all of these additional notices. This just says more of our responsibility. We're advising you to review the information that we submit to the MLS, review and contact any mortgage lender or lien holder to obtain information, payoff amounts, consult with an attorney before using any surveillance devices. Just go through all of these to make sure that you're in full understanding. And the very, very last thing is the broker cannot give legal advice. Read this listing carefully. If you did not understand the effect of this listing, consult an attorney before signing. Okay, that's it. That's the whole thing. Signatures are going to be here. The address of the property will be up top. Let me know if any of this was clear as mud. Hopefully this helped you understand a little bit more what you're signing. But yes, please read through the document on your own and give us a call with any questions that may arise. Thanks.